My name is Miriam Hatch Decker. I am 63 years old, and my stepchildren told me I married their father to get my hands on his business. Lance said it in the kitchen, 8 days after Roy died. His sister Sabrina stood in the doorway. Their Aunt Rosalind sat at my kitchen table with a cup of tea she'd made herself without asking. Lance set a cardboard box on the counter and said I had 2 hours to fill it. I didn't argue. I packed what I could carry and I left, and for nearly a year they believed that was the end of it. Here's what none of them knew going in. The man who built their legal strategy wrote every word of it himself. Every form, every paragraph, every date filed with the court. At the final hearing in Franklin County Probate Court, the judge asked him to read the first paragraph of his own exhibit out loud. He got 4 words past his client's name. Then he sat down and didn't pick it back up. Welcome to Strong Mom Stories, where the women who get handed the box end up deciding what goes in it. Drop a comment and subscribe, because what I found when I finally read the public record is going to take a few minutes to explain, and it is worth every one of them. I spent 32 years as an enrolled agent. That's a federal tax credential, licensed by the IRS, and I want to explain what it actually means because it matters to everything that comes after. An enrolled agent can represent any taxpayer before the Internal Revenue Service in any state in the country. I started in 1987, 25 years old, at Whitfield and Crane CPA on Broad Street in Columbus, Ohio. 6 months earlier, my father's estate had been mismanaged so thoroughly that my mother lost the house she'd lived in for 23 years. Nobody explained the filing deadlines to her. Nobody explained what she was entitled to. I watched her sign documents she didn't understand because she trusted the man sitting across the desk. I took the night courses. I got the credential. I spent the next 12 years at that firm, and the 12 after that running my own practice out of a small office in Westerville. You want to know what that job is at its core? It's reading numbers until you find the one that doesn't belong. The IRS sends a notice, you pull the return, you go line by line until you see what they're looking at and whether they're right. 9 times out of 10, somebody missed something. Sometimes it was the taxpayer, sometimes it was the previous preparer, sometimes it was the IRS itself. The job is not to assume, the job is to read. Roy Decker walked into my office in March of 2010 with a shoebox. He was 60, recently widowed, and owned 4 commercial rental properties around Columbus, 2 strip malls, a small office building in Dublin, and a warehouse unit he'd been leasing to a trucking company since 1998. The shoebox had 2 years of receipts, a lease agreement with a coffee stain across the signature page, and a depreciation schedule his previous preparer had stopped updating in 2006. He sat across my desk and said, "I'm probably a mess." I said, "Everybody who brings me a shoebox is a mess. That's what the shoebox is for." We were married on October 14, 2012, on a Tuesday afternoon at the Clintonville Community Center. Small ceremony, 40 people, his sister Rosalind in the front row with her arms folded the way she folded them at everything. I knew about Lance and Sabrina before I ever met them. Roy talked about his kids the way some people talk about weather in their home state, constantly, affectionately, with complete acceptance that it was going to be what it was going to be. Lance, 46 now, had worked in his father's property management company for 15 years and ran day-to-day operations on 2 of the 4 properties. He was good at it. He also believed with the quiet certainty of a man who had never been told otherwise that the sign out front would say Decker and Son one day. Sabrina lived in Scottsdale. She called every Sunday. She had her father's laugh and her mother's opinions about the people her father loved after her mother was gone. Roy died on a Thursday morning, in February, in his workshop in the garage, the way men who have workshops die. He was 71. His heart went while he was sanding a cabinet he'd been building for the back bedroom for 3 years. It was about 60% done. I don't know what he planned to put in it. 8 days later, Lance came to the house. Sabrina was already there. Rosalind had driven up from Chillicothe and was at my kitchen table with her tea. Lance had a cardboard box. Roy's handwriting was on the side of it. Miriam's office stuff, from when I'd moved my desk equipment into the guest room in 2013. Roy had labeled it himself with a black marker, in his block printing, the way he was about everything he didn't have feelings about. Lance set the box on the counter and said the family needed to talk about the house, he said. The properties. He said the business. He said Roy's will had been with Douglas Hargrove at Hargrove and Finch in Bexley for years, and it was clear about what went where. Then he said, "You managed his money before you were his wife. Everyone in this family knows what that looked like. Whatever you think is coming to you is not coming to you. You married him to get your hands on what he built." Rosalind said, "Lance, that's enough." Then she said, "Miriam, I think 2 hours is fair." Sabrina said nothing. She stood in the hall doorway and looked at me, and then looked at the floor. I said, "All right." I took Roy's cardboard box. I packed 2 suitcases. I took my reading glasses, my red pens, the photograph from our trip to Savannah, and the flannel shirt I'd been sleeping in since February. I left the good china we'd picked out together in 2015. I left the Afghan his mother had crocheted that had been on the couch since the year we married. I left without looking at the workshop or the unfinished cabinet. I drove to the apartment I'd kept on North 4th Street, $790 a month, 2nd floor, window facing a parking garage. I set Roy's cardboard box on the kitchen table and I did not open it. Douglas Hargrove called me the following Thursday. He is 62, Hargrove and Finch. Same building for 20 years. The Decker attorney since before I knew the Decker family existed. He told me the will was dated 2008 and left everything to Lance and Sabrina in equal shares. He told me the premarital agreement Roy and I had signed waived my claims to the estate. He told me there was a 6-month window to file a spousal election against the will, and he'd hate to see me spend good money on something unlikely to go anywhere. He smiled when he said 6 months. I heard it through the phone the way you hear a man lean back in his chair. I asked him one question. I asked whether Roy had ever come to him about updating the will after we married. There was a pause. Not long. 2 seconds. Maybe 3. Not formally, he said. I have spent 32 years taking information from people who are choosing their words while they speak, and I noted it. I said thank you and hung up. For 8 months, I did not look at the file. I want to be honest about why, because I think the honest version is the only one worth telling. If I hired a lawyer and fought for Roy's estate, Lance would say he'd been right all along. That was the whole calculation. If I walked away quietly, I kept my version of who I was. If I filed anything, I became the woman who married Roy Decker for what he had. No settlement figure was worth that to me. I called that dignity. I said the word to myself in the bathroom mirror on bad mornings. It wasn't dignity. It was pride in dignity's clothes, and I knew the difference and chose not to look at it. My friend Joanna Marsh called me in October. Joanna is 67, spent 26 years as a paralegal at a firm downtown before she retired, and she is the kind of woman who will let you talk for 40 minutes and then hand you the one sentence that matters. She asked if I had looked at the estate file. I said I wasn't ready to see my name not in it. She said, "Miriam, you spent 30 years finding what other people missed. Don't let them count on you being too proud to read the document." The Franklin County Probate Court is on South High Street. I have been there before, walked those halls, pulled forms, notarized things at the counter. The clerk handed me the Decker estate file without looking up. 2 inches of paper, rubber band, 47 pages. I carried it to the long table by the window, and I took out my red pen. The first document in any probate file is the petition to open the estate. Douglas Hargrove had signed it on March 3rd, verified it under penalty of perjury, filed it at this counter 3 weeks after Roy died. Paragraph 3. Decedent died testate, leaving a last will and testament dated August 12, 2008. I circled August 12, 2008. Paragraph 5. Decedent was survived by his spouse, Miriam Ann Hatch, whom decedent married on October 14, 2012. I circled October 14, 2012. I set the pen down and looked at those two red circles, 4 years and 2 months. The will came first. 4 years before Roy Decker and I were ever in the same room, he had sat in Douglas Hargrove's office and signed a document about his life as it was then. I asked for a copy of the will itself. Article 1. I, Roy Kenneth Decker, of Columbus, Ohio, declare this to be my last will and testament. I am a widower. I have 2 children. He was a widower in August of 2008. His first wife had died that January. He had 2 children. That was the complete truth of his life when he signed that page. Written down in a legal document, sitting in a file ever since, unchanged, while Roy and I went to Savannah. While I filed his tax returns, while we stood at the Clintonville Community Center on a Tuesday in October with 40 people watching. I went upstairs to the law library. Ohio Revised Code, Title 21. I found what I was looking for in 40 minutes. Section 2107(37), omitted spouse. If a testator fails to provide in a will for the testator's surviving spouse who married the testator after the will was made, the omitted spouse shall receive the same share of the estate as if the testator had died intestate, unless it appears from the will that the omission was intentional or the testator provided for the spouse by other means. I read it standing up. Then I sat down and read it again with my finger under the words, which is a thing I have made clients do at my desk, when a number on a schedule is doing something they don't want to believe. Article 1 of Roy's will said he was a widower with 2 children. It said nothing about contemplating remarriage. The omission wasn't intentional. It was a document written before I existed in his life. I checked Ohio intestate succession. Section 2105.06. When a decedent leaves children who are not also children of the surviving spouse receives the first $20,000 and 1/3 of the remaining's estate. I copied both sections longhand on my legal pad. Then I pulled the statutes up online to verify the book on that shelf was current. 3 ways. Same answer, all 3 times. Claire Dunmore's office is above a florist on Indianola Avenue. She is 44 and does nothing but probate and estate litigation. I put the pages on her desk on a Monday morning. She read the petition, read the will, read Section 2107(37. Then she said, "You didn't file a spousal election in October." "No." "Good," she said. "It wouldn't have helped you." She explained the difference. The elective share, the one Hargrove had mentioned in April with a 6-month deadline, is a claim a surviving spouse makes to reject the will. File it or lose it. I'd lost it. Section 2107.37 is not a claim against the will. It is a rule that modifies the will by operation of law the moment a testator marries after signing it. There is no window. There is no deadline. The share had been mine since October 14, 2012. The same afternoon, Rosalind sat in the front row with her arms folded. Hargrove had spent 8 months running out the wrong clock. The premarital agreement. I had it in my fireproof box, where I have kept every document I've signed since 1984. Claire read it carefully. The agreement referenced a complete schedule of each party's assets attached as an exhibit. She turned the page. Signature block. Notary. No schedule. "Where is it?" "There wasn't one," I said. His assistant told me at the signing it was in the file. Claire requested their copy under discovery. His copy had no schedule either. Ohio Revised Code, Section 3103.8, requires premarital agreements to include fair and reasonable disclosure of property and financial obligations. No schedule, no enforceable agreement. In May, a form arrived from Hargrove's office. Joinder, waiver of notice, and consent to distribution. He wanted me to sign it before the final accounting hearing. I read it twice at my kitchen table with my red pen. It waived my right to formal notice. It waived objection to the accounting figures. It consented to distribution per the terms of the will. 2 pages. There was no release. There was no waiver of rights under Chapter 21 of the Ohio Revised Code. There was no mention of Section 2107(37). The words omitted spouse did not appear on either page. Douglas Hargrove had taken a form he used for adult beneficiaries and typed a widow's name on the signature line. I signed it, blue ink, May 19th. I meant every word. I had no objection to the accounting figures. I didn't dispute a single line. I consented to the will doing exactly what a will can do. I just also knew what a will cannot do to a woman who is still alive when the page turns. Claire filed the pretermitted spouse claim the same afternoon. Hargrove answered 11 days later, one paragraph, letterhead, citing the wrong statute. He had answered a 2107-37 claim as if it were a spousal election under 2106-01. He never looked it up. The hearing was a Thursday morning in June. Franklin County Probate Court, second floor. Judge Carol Stein, who has run estate proceedings in that building for 16 years and reads a filing the way I read a return, line by line, no assumption. They all came. Lance in a sport coat, Sabrina with her husband, Roslyn in the second row with her purse in her lap. Two cousins I recognized from Roy's Christmas parties years back. I came with Claire and Roy's cardboard box, the one with his handwriting on the side. I carried it under my arm because it holds 47 pages flat and because I wanted to. In the hallway, Lance looked at the box. Something moved across his face, not recognition exactly. More like the beginning of a thought he decided not to finish. He had carried that box down from the guest room with his own hands. He had set it on the counter for me to fill. He said, "That's Dad's box." "I know," I said. "He labeled it himself." The bailiff opened the door. Hargrove presented cleanly. Roy's estate, commercial properties appraised at $2.8 million, certificates of deposit, retirement accounts, 2 vehicles. Debts paid, taxes current, proposed distribution in equal shares to Lance and Sabrina per the will. Exhibit A, the will. Exhibit C, my signed joinder and consent. He held that last one up a half-second longer than necessary. The surviving spouse has consented, Your Honor. Executed May 19th. Judge Stein had been reading the entire time. She took her glasses off and let them hang. Mr. Hargrove, paragraph 3 of your petition. The will is dated when? August 12th, 2008, Your Honor. Paragraph 5. The decedent married the surviving spouse when? October 14th, 2012. He married after the will was signed. Yes, Your Honor, but the surviving spouse has signed a consent. Read me Article 1. I know that pause. It is the pause a client makes when they finally see the number I circled and understand it isn't a typo. Hargrove picked up his own exhibit, the document he had typed in his Bexley office 14 years ago, filed at this court in March, and marked Exhibit A in June, and he read, I, Roy Kenneth Decker of Columbus, Ohio, declare this to be my last will and testament. I am a widower. He stopped. 4 words passed Roy's name. The man who had written that sentence in 2008 filed it this year and built an entire estate distribution on top of it, had finally, in a Franklin County courtroom, heard what the first paragraph actually said about the woman standing in his way. Sabrina said, "What?" quietly. Her husband put a hand on her arm. Hargrove set the will on the table and did not pick it back up, and he sat down. Judge Stein put her glasses back on. Mrs. Dunmore, Section 2107-37. Yes, Your Honor. Hargrove came back up out of his chair. The premarital agreement barred all claims. The election window had closed. The surviving spouse had signed a joinder and consent and could not attack the distribution after doing so. His voice climbed on that last one, in a way it hadn't done all morning. Lance was nodding at every sentence. Hargrove talked for 4 minutes. Claire stood up and used about 35 seconds. Section 2107-37 is not an election, Your Honor. There is no deadline. The right vested on the date of the marriage. The consent form waives notice and objection to the accounting. It contains no release. It does not reference Chapter 21. Mrs. Decker meant every word she signed. The premarital agreement lacks its required disclosure schedule under Section 3103.08, and opposing counsel's own file copy, produced in discovery, confirms no schedule was ever attached. Then I stood up. Once, the only time I stood up all morning, and I did not raise my voice because I have been in rooms with IRS, appeals officers, and with taxpayers who were terrified, and with taxpayers who were furious, and I have never once gotten what I was looking for by raising my voice. Mr. Hargrove, I said, you drafted that agreement. Every paragraph, every clause, every missing line. I only read it. I sat back down. Judge Stein ruled from the bench. She held that Section 210737 applied on the face of the record. She noted that Article 1 of the will demonstrated Roy had not contemplated remarriage. He identified himself as a widower with 2 children, a statement of fact about his life as of August 2008, not a forward-looking document. She held that the joinder form waived notice and objection to the accounting figures, and nothing beyond that. She held the premarital agreement unenforceable for want of the required financial disclosure. Under Ohio intestate succession, with children who are not also children of the surviving spouse, the share is $20,000 plus 1/3 of the remainder. 1/3 of $2.8 million is just under $950,000. Lance hit the table with both hands flat and said his father would never have wanted this and that I had manipulated everything from the beginning. The bailiff stepped forward. Judge Stein said his name once. He stopped. Sabrina turned around and looked at me for a long moment. Then she said, quietly, almost to herself, "He called Hargrove's office in 2020 about updating something. I saw the billing statement in a drawer at the house last spring." She turned back around. She did not look at me again. Rosalind sat very still and stared at the wall above the flag. Judge Stein, gathering her files, said one more thing in the flattest voice in the room. "Mr. Hargrove, I'd suggest you speak with your malpractice carrier before the fee petition is heard. Here is what happened after, in numbers, because feelings fade and numbers don't." The court entered a decree awarding me my statutory share. After Claire negotiated the distribution, I received the Dublin office building, appraised at $890,000, close enough to my share that it worked without forcing a sale of the operating properties. I did not want the business. I never wanted Lance's livelihood. I wanted what the law said I was owed, not $1 more, not $1 less. I filed a complaint with the Ohio State Bar Association, not because I lost 8 months. Because Roy called Douglas Hargrove's office in 2020 to talk about his estate documents, and that call apparently ended without a follow-up appointment ever being made. I moved back into the house in August. I set Roy's cardboard box down in the guest room, in front of my desk, where it belongs. His handwriting is still on the side panel, black marker, block printing. I am not going to paint over it. There is a window latch in the upstairs bathroom that Roy bought the replacement part for in the fall of 2019 and never got around to installing. The part was still in the original bag in the cabinet under the sink. It took me 20 minutes and a screwdriver to put it in. The window closes all the way now. I can hear it click from across the hall. Roy was not a bad man. He was a man who put hard conversations in a drawer and told himself he'd get to them. He almost got to this one. Almost isn't the same as never, but it's close enough that it cost us both something real. If you take one thing from today, take this. Being quiet is not the same as being invisible, and the day you stop waiting for someone else to explain your situation to you is the day you find out what the numbers actually say. Nobody handed me that courthouse file. I walked up to the public counter and asked for it. Then I sat down at the long table by the window and I read every page. That's the job, it always has been.